explain what the bill does, and we're going to go into public hearing. Thank you very much.
Mr. Chairman, if it's okay with the committee, I'm going to stay in that since it will be brief, but I do want the committee to know that they can diligent on that. Parties working on this bill to come up with a substitute by next week. We'll be able to, all the parties will be able to accept and move forward with, and this is one of those where it looked like a really good piece of legislation when I got it, and then fall out from under it. So I'm trying to get it back to where it can be, and if it's okay with you.
And I know you're working hard, and I know there's a lot of folks in this room working very hard, and I appreciate it. And I know a week from today, the bill will be worked out. That's the thing that makes me most satisfied. So with that, we're going to have our public hearing. Mr. Mattson, will you come up and start the public hearing as a proponent?
Yes, Mr. President. And thank you, members of the committee and chairman. Before this session, and it was last year, there's a lot of discussion about ways to defer and to lessen the population of folks going into penitentiary. And not just going in on an initial blush, but, probation, then revoke, and going back in our system. And the DAs in Alabama have done made a tremendous effort in deferring people as often as they can. Sometimes we say, go to penitentiary just about out a want to go. Probation, there's so many programs that are available out there right now, but still there's not enough. Drug courts are certainly effective, and we're supported by the DAs. There's a lot of community corrections, a lot of those programs out there, but there's still a hole in this net. And so what we want to do is create a pretrial diversion program. There are some 30-odd states that have these programs already in Alabama. 22 circuits in Alabama have a pretrial diversion program that work well and complement these other programs. 22 circuits, some 31, 34 counties have this program. The remainder do not have a program like this. And what we envision would be, and currently the bill, and I know that there's been a barrage, I would imagine y'all been in contact on this bill once or twice. I'm almost confident you've been contacted once or twice on this bill. And I understand that there are some differences where we should need to go with this bill, but I can tell you that, and you folks, you know me, you've seen me, I've worked with most all of you on the bill too, and we're working in good faith with the parties that are involved and concerned, judges, mental health, and anyone else, public safety has some issues, and we're willing to make this bill work. What we hope to get is a bill that a person can come in that may not fit those other programs, or maybe they do, but they've either washed out or they just don't fit quite right in those programs, and this is another vehicle that a person can come in, and it's voluntary. There's nothing required. There's no mandate. A person who has an attorney, or maybe they're in a traffic situation, or in this case, and they make an application, there is an agreement in writing that they enter into and the DA enters into that says, I expect this of you, and in return this will happen. They would enter a plea of guilt. That sentencing will be deferred for the period of time they're on deferment. It could be 6 months, it could be longer, based on the written agreement that everybody understands. At the conclusion of that, if they lived to the cross and acted right, and done all the things they should have done, and passed the drug test, gone through mental health treatment, whatever's been the need has been for that person, then it may be malpractice, it may be, they may plead to another charge, and that, whatever the agreement is. But it's the bill before you does not have some of the language that I'm committing to you will have in the sub. We do not want the court system or the state to have one penny taken away from court cost fines and fees. So that, in the sub, it's already in the bill that we're working on. Court costs and fees, those things will be paid. There's some oversight that judges wanted to do that. We want to have those in place. What we did was we took the local bill from several counties and model act around the country and kind of molded those together to create this bill. And we stand ready to get it right. I suspect we'll have a sub by the end of this week that will address these issues, and we hope to get to you before the end of Friday, and we can look at it and vote on it next week. We will agree on what we can agree on, and what we can agree on, we'll state it clearly and transparently so you'll know and everybody know what we haven't agreed on, and you can vote and make your conscience and decide when you lay there. But I think we can do that.
All right. Thank you very much. Next for the public hearing, Foster Cook. Hang on. Barry, President England has a question.
I just had a couple of questions. As far as jurisdiction is concerned, how how does this affect municipal courts across the state and their adoption of their own pretrial diversion?
Okay, we had talked with folks at the league, and there was no desire on their part, anyone's part, to make municipalities mandated to be part of it. I know some municipalities have their own programs, we support those programs, but we left it open-ended. If a city wants to have a program but do not have a local act, or want to have an MOU or agreement with the DA to do that, I think that the bill is open enough for a city to say, we want to incorporate, we want to be part of this program. I understand that language that I've been told, I've not talked to folks in municipalities from some of the cities, they would like specifically to say the city can opt in or opt out, be a part of or not be. And I'm fine with it, because we don't want it to be mandatory on the cities at all. But if the city chooses to, I'm sure we have a problem in being part of this pretrial program on their case, it would be by agreement on it.
Right, because there's some language in the bill currently in section 5 that essentially makes the district attorney's pretrial program, I think the word specifically is notwithstanding current law, administered to the pretrial diversion program shall be in the sole discretion of the district attorney and shall be paramount to any other diversion type program available to the defendant. I think a lot of us would be a lot more comfortable if that language was removed and replaced with something that says specifically that municipalities can are allowed to adopt their own pretrial diversion programs and can operate without any sort of interference from the district attorney's program.
And that, I support that language. Where that paramount language came from is there was some talk earlier in the session about a first offender bill, which in my opinion, one of other people's opinion would have decimated drug courts and any other early programs, because he's going to not get adult people offender basically and not go through a program. And then we're going to send them right back to the cycle because they're going to take the easy way out. So the paramount language was to protect this offender, which is not going to move. We've already agreed to take that out and actually to make drug courts paramount to this program. We don't want to interfere with drug courts. We don't want to interfere with these programs at work. We certainly don't want to interfere with municipalities. We'll make that change. We will not interfere with municipalities. There were some folks that wanted to put something in the bill that allowed municipalities to create their own programs. We don't oppose that. I just don't have that language. I don't have that wording to do that. We don't want to take away from municipalities.
Okay, one more question?
Yes, and also, section 7 of the bill appears to create some sort of pre-arrest, pre-trial diversion, and I don't pretend to know how that happened. I can imagine there's in my mind immediately pops about a million constitutional issues in a situation like that, whether it be before arrest or before indictment or however. I mean, that to me opens up a very nasty box of constitutional violations when it's before an arrest that you may have someone who's charged with a criminal offense, and before someone determines probable cause, you have a district attorney or someone negotiating with that person, saying, we could execute a warrant for your arrest, but if you agree to go through our program and you complete our program before your